Yes.
Go ahead, Mr. Umlauf, when you're ready.
Is it true that you are married to the defendant, Jerry Marie Diaz?
Yes.
Do you have any children with Ms. Jerry Diaz?
Sí.
Yes.
Is it true that Jerry, after separation, had another child named Sarah that is not yours?
Perdón.
Sí, es correcto.
Yes, that's correct.
And the issue of her paternity was dealt with at a previous hearing in this case, correct?
Sí, es correcto.
Yes, that's correct.
To the best of your knowledge, is the defendant pregnant?
No.
No.
Do you recall signing a complaint for divorce in September of 2022?
Sí, es correcto.
Yes, that's correct.
At the time that you signed the complaint for divorce, had the defendant, Jerry Diaz, lived in the state of Michigan for 180 days in Calhoun County for at least 10 days?
Sí, es la zona de Battle Creek.
Yes, in Battle Creek area.
The complaint states that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Was that true today? Does that remain true today?
Sí, es cierto.
Yes, that's true.
If the court were to refuse to sign your judgment of divorce, is there any chance that you would be able to move back in with Jerry Diaz and live as husband and wife?
No.
No.
Have you reviewed and electronically signed the judgment of divorce in this matter?
Yes.
Do you believe that the terms in that judgment relating to your children are in their best interests?
Sí, definitivo.
Yes, definitely.
Do you believe that the division of property is fair and just?
Sí.
Yes.
Are you seeking spousal support?
No.
No.
Do you understand that by not seeking spousal support today, you are giving up your right to come back in the future and ask for it from the defendant, Jerry Diaz?
Sí.
Yes.
Did you agree to the terms in the judgment of divorce of your own free will?
Sí.
Yes.
I have nothing further, Your Honor.
Ms. Diaz, are you disputing or contesting anything in this matter?
No, sir.
No.
Thank you. Mr. Guerrero, you had filed to seek to get an interpreter for this proceeding.
Sí.
Yes.
Are you working, sir?
Sí.
Yes.
And where are you working?
Boston, Massachusetts.
In Boston, Massachusetts.
And what is your yearly income, sir?
More or less 75,000 to.
How much? Tell me. I didn't catch that.
Okay. More or less from 75,000 to 90,000 a year.
Okay. Well, based upon your statement as to your income, sir, I am going to deny your request for the court to be responsible for the cost of the interpreter. You don't qualify as having income less than the federal sanctioned poverty level. So you will have to pay the cost of the interpreter, sir. You understand that?
¿Entiende eso?
Sí.
Okay,
Yes.
Thank you.
Muchas gracias.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The defendant has appeared and stated she does not contest or dispute anything. The court will therefore enter the judgment and the uniform child support order submitted in this matter.
Como fue enviada en este asunto.
You are now divorced, and best of luck to both of you. Hope that everything works out for you.
Espero que todo les vaya bien.
And you're free to go and have a good day. Of the plaintiff,
Pueden ir, tengan un buen
the
día.
defendant appearing in pro per. This matter is before the court on the plaintiff's motion as it relates to holiday parenting time and exchanges. I've read all the pleadings. Mr. Mays has filed an answer. I've read that answer as well. Anything else, Ms. Bendelay?
Your Honor, I would just supplement. I noted on my court, and as the court indicated today, that defendant filed an answer. I've not received an answer from defendant, just for purposes of the record. I'm not sure what necessarily proof of service said. I would further supplement in our pleadings. We had referenced that there was a PPO between my client and Mr. Mays's girlfriend, Ms. Tiffany Lawhead. As I understand it, Judge Yost Johnson did subsequently dismiss that PPO. However, that order from Judge Yost Johnson indicates that the parties were advised on the record not to have contact, as both parties expressed they did not want contact. I understand Ms. Lawhead was inquiring of further PPOs. And so as supplemental nature for the court's understanding, those PPOs were dismissed, but our request for no contact as to exchanges, or for Ms. Lawhead to not be present at parenting time exchanges still remains. I would also supplement, to the extent that the court would make reference to it today. In the interim order, it indicates that the parties are to submit their financials to counsel, to plaintiff's counsel, so myself, for purposes of calculating a UCSO. I would just note that I've not received financials from Mr. Mays, and if the court is so inclined to direct Mr. Mays to ensure he gets those financials to me so we can get a UCSO calculated, I would greatly appreciate it. Otherwise, Judge, we would restate the relief requested in our motion.
Okay. Thank you. Mr. Mays, I did review your answer. I would agree with you. As I read the order, it was very confusing. I can understand why there might have been, again, misunderstanding as to who was to have Thanksgiving. It's my understanding you had no Thanksgiving, sir. Is that correct?
Yes.
Okay. What the court will do is I'll ask Ms. Bentley that you redo that order and do it such that it states that the plaintiff has Christmas Eve 2023, and then we alternate each holiday thereafter. Take out the confusing language about having plaintiff and / defendant or plaintiff - defendant. Quite frankly, I've never seen an order done that way. And when I read it, I go, well, if you read that order, how would you know who had what without at least saying a start date or a start, vacation? So change that. The court will order that the parties would be entitled to have a third party present during the exchanges, but the third party would remain in the car, would not interact with the other party, nor would they interact with anybody else, the other third party that's present as well. With that, Mr. Mays, does that take care of some of the issues you had?
Yes, it does.
Okay. Ms. Bendelay, you can prepare that order and submit under 7 day. Mr. Mays, you do have to provide financial information to Ms. Bendelay so she can calculate the child support, okay?
Judge, I would note that I had filed, or I'd mailed to the court a proposed order updating the parenting time schedule to omit the parentheses. Is the court asking that I resubmit that order 7 day?
Resubmit it and put in what I've put in about the third party, and resubmit it stating that your client would have Christmas Eve 2023, and then we would alternate the holidays thereafter.
Thank you, Judge. I'll do that.
Okay. Thank you. That will conclude the matter. We'll end this matter at 9:07 a.m. We'll note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Sharp on behalf of defendant. We have two matters before the court: the defendant's motion to modify custody and parenting time, and plaintiff's motion to modify parenting time. I think Ms. Sharp's motion might have been first, Mr. Schaefer, so we'll let her go first.
Thank you, Your Honor. My client filed a motion to modify legal custody and to modify the parenting time. Right now, he does not even have a standard schedule of what would be awarded. I know that Calhoun County doesn't have a specific parenting time standard schedule, but in most counties, he could be afforded, half the summer, a Wednesday visit. He doesn't have either one of those. Not being able to have that has limited his ability to have, to I guess, encourage and also continue a close relationship with his daughter, Ava. Ava's the only one that is currently actually in question in this order, since Mia now is at an age where this order no longer applies to her. But my client has ample evidence to show that there is extreme situation of parental alienation. And this evidence, even after the last court order, it shows mom encouraging the child to, take pictures, to not listen to her father, to, do these different things that would alienate her from her father. I do believe that based off of that, just alone, one of the factors encouraging a close relationship with the child and the parent that alone, my client could show that, that this has not been happening. This is a history of not happening, but also that it has not been happening since the actual last court order. It's only gotten worse. My client has not been able to be involved in anything. I mean, she's supposed to be informed of medical decisions or anything regarding the medical. He has no access to it. He only receives any information based off the fact that he receives bills. And then actually can see what may have occurred in that situation. But without having legal custody, he doesn't have that ability to be involved, nor is he being informed of that. Alone, just from seeing, one of the bills, the eldest minor child was put on birth control. And my client was very surprised by that to begin with. And again, this is occurring after he no longer has legal custody. So, Your Honor, my client is directly asking to be able to have more time to encourage a close relationship, given the fact that he has been alienated, and also that each year or each few years that they're trying to strip away more and more of his parenting time, and also more and more of his relationship with his daughters, and now just Ava. There's absolutely no reason why this should be occurring. He should be able to have the same legal I've seen some terrible parents have joint legal custody in addition to be able to have the actual standard schedule where he's having half the summer in a Wednesday visit. He can come to her to do that Wednesday visit. He's capable of doing that. I know that mom's moved away. And so, and she's been moved away, but so my client is requesting that he have that Wednesday visit and half the summer. If the court's inclined, he would request that the court set this in front of an evidentiary hearing in front of a referee, where it could be shown, that this alienation is occurring, that these messages are occurring, and also be able to rebut anything that she's saying in her motion. I can wait to respond until after this other motion, after Mr. Schaefer goes.
Okay.
Thank you.
Mr. Schaefer, you can proceed.
All right, thank you, Your Honor. In response, we have filed our answer, and contrary to what is alleged, currently the defendant has standard parenting time, and Calhoun County does have specific parenting time. If you look on the order of 2/12 of 21, it specifically sets out the holidays, sets out the summer parenting time. It's all standard. What they do in St. Joe is irrelevant to this particular matter, but that was pursuant to that consent order, so I'm not sure what that is all about. And the last order in this matter is June 6th of 23, where there was a hearing, and that was litigated, and the order was 6/6 of 23 that did away with the legal custody for the defendant, and my client, the plaintiff, has sole legal custody. So the only allegation in the petition is under paragraph 13. And I don't think that rises to the level of Bavarka to address any adjustments in legal custody, which is being argued today. There are three allegations therein. It has to do with coaching, manipulation, and threatening. And I'm not sure that rises, even if true, to Bavarka. So I think that the motion by the defendant as to custody should be dismissed. The motion for parenting time, he already has what they are asking for. We're asking for costs, so this is a frivolous motion. In relation to our petition for change in parenting time, we have set out many allegations that indicate that this child is suffering from the current situation in the parenting that she is trying to have with her father, but is being cut off by the stepmother. But the sanitary issues, the cameras that continue as of this last weekend are in the house pointing at her room, so she has no privacy. Everything is searched. She is in constant harassment from the stepmother and has no opportunity to have one-on-one with her father, which she would like to continue. But we are asking for modification of the parenting order, that it not be overnights, that to be at some other location with the father alone, without the stepmother there. So the child does not have to deal with the harassment, of bad mouthing her mother during the time of these visitation. So that's my response, and I'm asking that the defendant's petition be dismissed totally. And if in fact there are questions in relation to our parenting time motion, it probably should be set for a hearing.
Okay. Ms. Sharp, any response?
Yes, Your Honor. My client will be able to provide, I guess, evidence to show that a lot of these statements are untrue. You know, the pictures, my client actually has a housekeeper that comes to the house to clean the house. The cameras are there for security, partly for security reasons, but my client has also caught the child going in and taking pictures, and then seeing that it's being guided by mom to go take those pictures. And so, you know, a lot of this has been at issue, and I believe that a lot of the issues that have come up where there's, I guess, a statement that the child does not feel or have any kind of close relationship with father. I don't believe that that's based off the stepmother's any kind of thing that the stepmother is doing, but mainly because of the plaintiff's actions. A lot of these statements, though, my client will be able to rebut easily. Our response is pretty detailed, but we'll be able to rebut through evidence to show that these statements are untrue. Thank you.
Thank you. Anything else, Mr. Schaefer?
No, Your Honor, but I guess I'd reiterate that I think that the defendant's motion should be dismissed based on the arguments set forth.
Okay. Well, the defendant has stated that he's not entitled or he's not able to get medical information, et cetera. Clearly, he's entitled to, pursuant to MCL 722.30, he can acquire that information directly from the doctors or school or whatever. So I don't find that to be a argument has much legal or factual basis in this matter. Both of the parties has requested a modification of parenting time. The court does believe that there's a sufficient basis pursuant to Shade v. Right to have an evidentiary hearing as it relates to parenting time. Although the court is convinced that there has not been a meeting of the threshold for Vadvarka, there's not been a proper cause or change in circumstances sufficient for an evidentiary hearing on custody. So the court will refer the matter to the referee for a hearing on parenting time. And as both of the parties have requested the modification, the court is going to deny requests for attorney fees at this time. The court will do an order referring it to the referee, and that will conclude this matter. Thank you. You're free to go. Have a good day. Good morning to everyone.
Good morning, Your Honor.
Court will note the appearance of Mr. Sullivan on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for modification of custody. Mr. Sullivan.
Thank you. To begin, Your Honor, I would note that the motion to modify custody was served timely. It was served on 12/1/23. It's now 12/11. I've not received an answer to the specific allegations as required by court rule with or without counsel. But to get into the substance of the motion, Your Honor, as you indicated, it's a motion to modify custody, and it's also a motion to suspend parenting time. The essence of the basis upon which we seek this relief is that the minor child is really in a state of crisis. She is engaging in self-harm. That self-harm is directly related to the actions of the defendant father. The substance of that is spelled out in paragraph 5, subsections A through J. The minor child was taken by plaintiff mother on 12/1/23 to Bronson for a mental health evaluation. They evaluated her. They provided her with a safety plan. And in connection with that, mother has a counseling session set up on 12/13/23 with Elizabeth Alderson at Serene Solutions in Kalamazoo. There's also a CPS investigation that's ongoing. As you can see from the pleading that we filed, there are educational professionals at Calhoun Christian School that believe that it's not appropriate right now for the minor child to have contact with defendant. There is a safety plan that's been agreed upon at least for 30 days, but we're asking for a suspension of parenting time, the granting of the motion, and then engage in a hearing at which full evidence can be presented.
Okay. Anything else, Mr. Sullivan?
No.
Okay. Mr. Hayes, what's your response?
My response is that these are merely allegations, and upon my it was my current knowledge serves me right now. When she was taken in for the examination, there was nothing found indefinitely to prove that these allegations are true. As it stands right now, it's my word versus theirs, and I'm not in any way, shape, or form guilty of the things that I'm being accused of. I'm not in any position to want to hurt a little girl who all I wanted to do was give her a dad because I never had one, and it makes absolutely no sense whatsoever for me to take this child in and love her, and it just doesn't make any sense. Nothing about this case makes sense. The daughter that they are telling me allegedly that what my daughter has told me is, or what they have said my daughter has said, did not come from my daughter's mouth. As far as I know, these are all things that she has allegedly said to other people. And I can tell you that there are teachers at that same Christian school that'll tell you the exact opposite of what is being brought forth before you this morning.
Okay. Okay, thank you, sir. Anything else, Mr. Sullivan?
Right. You know, Judge, the infliction of emotional and mental abuse is not something that is symptomatic by a bruise on the body, but it's internal damage. It's somebody who engages in self-harm because they are so belittled and their self-esteem is so low as a result of the actions of defendant father that that's how they cope with it. They don't like themselves, and so they cut. The injury is so internal for this child, and we're asking that we move forward for the reasons that are stated in the motion.
Okay, thank you. Well, the court does notice Mr. Sullivan had represented the CPSs involved, so we'll get some information there. The court does believe that based upon the allegations, and Mr. Hayes, I understand they're only allegations at this point, but the court does believe that based upon that the Varka threshold has been met for an evidentiary hearing relating to custody. So the court will grant that hearing. I'll refer it to the referee for an evidentiary hearing. In the interim, the court is not going to, I'm not going to suspend parenting time without an evidentiary hearing or without more than mere allegations have been stated at this time. The court will state for the parties edification. I note there was also some allegations in the petition about texting or sending videos or other calls to the child during school hours. The court would order that the parties not contact the child during school hours, but they can communicate with the child after school hours or let's say any other time, but not during school hours to, again, cause the child any particular problems. So, Mr. Sullivan, I'll ask that you would simply prepare an order which would state that the parties would not text, send videos, or call the child during school hours. And the court will do the remaining order as it relates to a referral for an evidentiary hearing.
Thank you, Your Honor.
Okay, thank you. You're excused and have a good day. This matter was before the court set for a debtor's exam. Ms. Mueller, it's my understanding, well, we note that we have checked repeatedly, find out that the defendant did not appear. What's your preference?
Good morning, Your Honor. My preference is that a bench warrant be issued in light of the fact that the defendant was personally served and chose to ignore a court order. The judgment in this case is $40,772.38. If Your Honor would kindly take that amount into consideration when awarding the bond.
Okay. Well, the court will, at this point, the court will enter a bench warrant in this particular matter. We will set, in the interim, we'll set a, what's your thoughts on bond, counsel?
Well, Your Honor, it's, my experience has been that it's always good to set it somewhere in the area of no higher than $5,000 because you aren't going to get it and they just end up not coming in or not going to jail anyway. But $5,000 usually gets their attention and brings them in. $500 they pay it and then they just run.
Yeah.
So
what I'm going to do is I do note that in this matter that you have appeared. You've obviously taken action to get the matter in. The defendant has not appeared. what I'm gonna do is I'm gonna set the bond in the amount of $2,000. That way we know that we do have cost in that covered at least, and that will be the order of the court that bench warrant will issue with a bond in the amount of $2,000.
Thank you, Your Honor. It does, our office will get that to you, right?
That's fine. You can get it to us under, court will note the appearance of Ms. Sharp on behalf of the plaintiff. The matter is before the court on two matters, the defendant's motion for entry of order setting aside default and plaintiff's motion for entry of temporary custody parenting time order. Why don't we start with Ms. Moore first? Ms. Moore, you can proceed.
Your Honor, I am asking you to transfer this case to the venue where the minor child resides. By the plaintiff's own admissions in his UCC JEA in his complaint, he admitted that our daughter did not live in Calhoun County.
Okay, let me stop you, ma'am. We've got two matters and we're motioned for entry of orders. The issue of change of venue is not before the court today. If you want to change that, you're going to have to file a motion to do so.
This was adjourned 2 weeks ago in the matter of the correct venue and dismissing or transferring the case. You adjourned it because the plaintiff needed time to find counsel, and then
Okay. Did we have that?
She didn't renotice that.
Yes, I did.
Your Honor, I'll waive notice if the court's in agreement with.
Okay, it didn't get put on our calendar, ma'am. That's why I was a bit surprised, because the clerk's office didn't put it on our schedule for today. Just all they put on were the two. Let's take care of the orders first, and then we'll go to your motion then, ma'am. You filed a motion for entry of the order setting aside default. I note that back on the hearing on November 13th, it was stipulated that the default would be set aside, correct?
Yes. I received the 7-day order that you had signed for the default, setting aside the default. So I'm under the impression that the default has already been set aside.
Okay, well.
Let's see, that should have been.
Oh, okay.
I have the order to set aside default in our queue is not signed. So.
Okay, well, we'll check into that. It doesn't appear to be signed yet, but again, unfortunately, some confusion at the clerk's office and putting it in, but not forwarding it to the court. So you have no issue with that. The court will enter that particular order.
Thank you.
What's your response to plaintiff's notice for entry of the temporary custody parenting time order?
Okay. I apologize, Your Honor, as I did not receive his motion until Friday, and I was unable to prepare a written response.
That's fine. Go ahead with whatever response you have.
Okay. Your Honor, I take full ownership for mistakes I've made, but I want to be clear that this motion only tells one side of the story.
Well, that's fine. What it is, it's the order. It's not the motion, ma'am.
Okay, well, it is evident that the plaintiff and I are not good for each other, and it is the best interest of all parties for us not to be together, which is why I left Calhoun County on 10/16. The plaintiff has contradicted himself many times by sending emails saying that I'm a great mother, that he wishes we could be together, and asking me to come back. Many of those messages were from last week. If the plaintiff truly felt the way he states in this motion, then he wouldn't be sending me those messages and begging for me to get back together with him. I disagree with the plaintiff's statement that I provided an unsafe environment for our daughter, when in fact I uprooted my life and started over to provide a safe and stable environment for our daughter in Oakland County. I secured a home, stable employment, and stable childcare. Your Honor, I'm asking that you do not grant the plaintiff his motion for temporary parenting time. Your Honor, I left Calhoun County on 10/16, and the plaintiff was informed of our new home and was offered to see our daughter on 10/22. But he did not reply and did not ask to see her until 11/17, which was 30 days after we left Calhoun County. I've never tried to keep our daughter from the plaintiff. I offered the plaintiff parenting time with our daughter so that he could begin to build a relationship with her and learn how to take care of her, which is why I offered supervised parenting time. In the plaintiff's motion, he states that on 11/30, the police were called, and they were in fact called, but by the plaintiff. The plaintiff arrived to his parenting time with the police and tried to enter my home demanding to take our daughter, and my aunt is here and able to testify to this. Additionally, I have obtained the police report from that day. Your Honor, the plaintiff does not know how to make a bottle. He doesn't know our daughter's doctors, how to put her to sleep, how to console her when she's upset. He's never been alone with our daughter. I'm trying to act in our daughter's best interest. I've been our daughter's primary caregiver from the day she was born 6 months ago, and it would be detrimental to her to take her from her home in the only care she has ever known. I'm respectfully asking that you grant the plaintiff the parenting time that I had previously offered to him, which was twice a week. 1 weekday for 2 hours and 1 weekend day for 3 hours of supervised parenting time so that he can establish a relationship with her and learn how to care for her so that one day he is able to have unsupervised parenting time and we can have shared custody in the future. It is my genuine desire for the plaintiff to have a relationship with our daughter and get to know her and learn how to care for her. I'm just asking that he learns to do that before he is granted unsupervised time for her. Thank you.
Okay, Ms. Sharp.
Thank you, Your Honor. As my client, I guess he did not provide me an actual request to enter a temporary order, but I can definitely argue that the statements said by the defendant actually have a different timeline here. So it's said that my client has never taken care of the minor child, yet the parties lived together multiple different times throughout this period. So this my client jointly had this child and was helping take care of the child. So this child is on formula, not on breast milk. She's on formula. And so my client has been able to and has done the formula before. He also has been left alone with this child before. This isn't he's the father. He knows how to take care of his child. It isn't that, he never lived with his child, now is asking for some kind of visitation because the child's never met him. Instead, it's mom just took off and left. And my client in September could see something was going to go on here, that mom was going to, be going back and forth, and he had concerns. And so he filed then, and then she came back. And then she left again October 16th. She then blocked him from him being able to talk to her. And then finally started allowing some kind of visitation. It was my client's birthday on the 30th. He tried to actually get his child. And she informed him he could have supervised visitation for a few hours. There's absolutely no reason why my client needs to have supervision whatsoever. He's never hurt this child, been physical. The only person that's been physical is the defendant. And, she physically actually assaulted my client while she was holding the minor child on October 16th. And so my client is looking for, based off the physical assault, he was looking for sole primary custody, physical custody. But, if the court is inclined, he would, at least like joint physical custody where he could take care of the minor child, because there's absolutely no reason why he wouldn't be able to. And there's no kind of history. There's nothing alleged that's wrong with him other than just claiming, that he can't take care of his child. Yet he lived with the defendant for a while with the minor child in their care. So, Your Honor, my client would ask for at least, he would like joint legal custody. He'd like primary physical, but the court is inclined at least joint physical custody and a parenting time arrangement that's good for both parents and a minor child of that age, where the child does not go very long without seeing either parent. But my client is capable of doing overnights. He's capable of taking care of the child on his own without the defendant present. Thank you.
Okay, thank you. Do we have that temporary order? I can't find it now.
We do not. Not for the motion. Harris was the motion for temporary custody and parenting time. The temporary order was on the defendant's motion for.
Okay, so we didn't have another one.
We didn't.
Okay, Ms. Moore, what's your response to Ms. Sharp?
Your Honor, none of that is factually correct. We had lived with the plaintiff, but he had never once helped me ever. Maybe he would feed her every once in a while. He was not an active role in her life. He would go to work, he would come home, and then he would smoke and drink in his game room for hours. There was days I was begging him to help me and spend time with us, and he would not. Your Honor, he is not fit to take care of her. He has never woken up with her in the night, Your Honor. He has never done these things that you would do in overnight visits. He has never been alone with her for more than an hour, maybe while I run to the grocery store, Your Honor. None of this is factually correct. We never agreed on the unsupervised visit, so him showing up to my home with the police trying to force his way into my house was incredibly disrespectful, especially because we had an agreement and he violated that agreement and just made me feel like I can't trust him. He's showing up to my house with the cops. His living conditions are honestly a health hazard. I have pictures, I have videos. It's disgusting. There is an infestation of bugs. I am honestly worried for her well-being if she was to go unsupervised. This is why I'm trying to do supervised visits. It's been 2 months and he's seen her one time in the last 2 months. She's 6 months old. She does not know him, Your Honor. I'm asking for these supervised visits so they can build a relationship, so we can get to the point of unsupervised visits and sharing custody. I don't want to keep him from her, but I'm honestly scared for her safety and well-being of him being alone with her.
Okay.
Your Honor,
Anything
may I
else,
make one
Ms.
statement?
Sharp?
Yes. Okay, so the only reason my client has not been able to have contact with the child is because of the defendant. So
No,
if the
it's
defendant was
not.
concerned with the actual the child having a relationship with the father, then she wouldn't have blocked my client and she wouldn't require supervised visitation, because supervised visitation, if it had started with visitation from the beginning in October, then I don't even know. To begin with, I'm not sure why supervision should occur, but regardless, if she would have allowed any kind of visitation in the October, then she wouldn't have that argument saying, he doesn't know the child.
Your Honor,
Regardless,
Ms. Moore, don't interrupt. Go ahead, Ms. Sharp.
Thank you. And my client filed because he did not want to have parenting time dictated by the defendant, as it has been happening. He filed right away. It shows that he cared about having the child in his life, and he didn't know where Miss Moore would be going back and forth, back and forth. And so that is the reasoning why in the first place he filed. So it shows that he cared from the start and would like to have this child in his life as much as the court allows. Thank you.
Thank you. Ms. Moore, anything else?
Your Honor, he did not ask to see our daughter until November 17th. We left October 16th. He was texted by my aunt on October 22nd, and he was made aware of where we were, that we were living here, and he was given multiple dates and times that he could come see her. He never responded. And I think it's important to add too that he was never blocked. While we were living together, we had an agreement that I was a stay-at-home mom and he would pay my bills. He never paid my phone bill, so my phone was shut off. Any texts or calls he had sent me, I did not receive. He did not ask to see her until November 17th. I tried to do visits in October. He never responded, Your Honor.
Okay. Well, he's asked now, so we have to address that at this particular point. So,
Your Honor, I am asking that we could go over the motion to transfer or dismiss, because that was the first.
well, but you acknowledged that you had resided in Calhoun County prior to October 16th.
Yes,
2023.
Yes, but we have resided in Oakland County for 2 months now.
Well, that's not going to be a determinative factor as it relates to venue, because you had resided in Calhoun County, and the court will find that Calhoun County is the proper venue at this point.
But however, when he filed it, we were living in Washington County.
Well, he was residing here. He had a right to file in the county in which he resided. He did file, so the court is going to continue to take jurisdiction in this matter. What the court is going to do is, on a temporary basis, the court is going to temporarily grant to the defendant legal and physical custody. The court is going to grant parenting time to the plaintiff, standard parenting time, but on the alternating weekends, that would be from Saturday at 9:00 a.m. to Sunday at 6:00 p.m., as well as the midweek on Wednesday, if the parties can other agree, for 4 hours. The court would grant to him alternating holidays in this matter during the standard alternating holidays, but I'm not going to extend that for a Christmas. I'm not going to break up the Christmas break. It'll just be the holidays themselves at this particular point. And the court would grant to the defendant child support based upon the respective incomes of the parties, based upon the child support formula as well. Ms. Sharp, you can prepare the order as it relates to custody, parenting time, and support in this matter and submit it under a 7-day notice of entry.
Thank you, Your Honor.
Anything else, Ms. Sharp?
I just want to make sure what weekend my client can start.
I will have that take effect starting this weekend on December 16th and then alternating each weekend thereafter.
Okay, thank you.
And why don't we do that too for the holidays? Put that. I'll ask Ms. Moore. Ms. Moore, do you wish to have Christmas Eve this year or Christmas Day?
Christmas Day.
Okay, we'll have the plaintiff would get Christmas Eve 2023 and then alternate each holiday thereafter.
Your Honor, just to be clear, you're granting the plaintiff unsupervised
Correct.
overnights for the weekend?
Correct. Okay.
So that goes for, can you go over the times again for the weekend?
The weekend would be Saturday, his alternate weekend, Saturday at 9:00 a.m. on Saturday to 6:00 p.m. on Sunday. And then the holidays would be based upon the front of the court holiday schedule. Those days, those times vary based upon the holidays. But Ms. Sharp will include that in the order. That will be the order. The court will end this matter at 10:54 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note the appearance of Ms. Henderson on behalf of the defendant. This matter is before the court on the plaintiff's motion to set aside the referee recommended order in this matter. Ms. Barris, I note that you had raised many issues and objections, but the court just simply can't ignore the referee's recommended order unless you are able to establish that there is a factual or legal error in this particular matter. So what do you believe to be the basis for setting aside the referee's order?
So I am going to ask if I can adjourn this for time to get the transcripts, so that I can provide that as well.
Okay, Ms. Henderson, what's your thoughts?
Your Honor, as we stated in our written response, there are no allegations of factual or legal error that would have been conducted by the referee. We had a 4-day trial spanned over months. There's no allegation that there's any new evidence or evidence that was not available during the trial, Your Honor. So I would ask that the court affirm the referee recommendation. Generally, transcripts are ordered at the time that that motion is filed. Ms. Barris did not do that, Your Honor, so I would ask that the court proceed and affirm the referee recommendation, as case law is very clear that the trial court's order concerning child custody shall be affirmed on appeal unless the trier of fact made findings of fact against the great weight of the evidence or committed palpable abuse of discretion or a clear legal error.
Okay.
That's Piron v. Piron. So there's no allegation that happened, Your Honor, so the court should affirm the ruling made by the referee and make that the order of the court.
Okay. Well, what the court's going to do is they do note that, as you say, oftentimes the parties will order those transcripts, but they don't get them often until sometime after the hearing. So typically we do have to put these hearings over so that they can get the transcript anyway. So Ms. Barris, I'm going to give Ms. Barris the opportunity to get the transcript. Ms. Barris, you can do that. I will give you up to 30 days to get the transcript. And if you need to file a modified or amended motion, I'll allow you to do that. Then Ms. Henderson can respond, etc. But you'll need to, I take some dispatch in getting this done so that we'll adjourn it up to no longer than the 30 days for you to file the transcript and the amended motion if you wish to do so. Okay.
Sounds good. I appreciate it. And I requested the transcripts will be today. So that's what I'm working. So they said that it takes they said to prepare the transcripts. They'll let me know when they're ready for them.
And then you'll have to renotice this matter up, Ms. Barris.
Sounds good.
Okay, thank you.
Thank you.
Charles Henricks
Thank
versus
you.
Victoria McFadden, Attorney Sanger for plaintiff.
Okay. Good afternoon to everyone.
Good afternoon.
Good afternoon.
Ms. Fannin, in this matter, McFannon, this is a scheduling conference whereby the court puts in place various dates and processes so that the case will proceed in an orderly fashion. So what I will do is I will go to Mr. Sanger first as he represents the plaintiff, and then I will go to you. So every time I talk to Mr. Sanger, I will speak to you as well to get your input. So don't feel that you're going to be left out in any manner.
Judge, I have not had a chance to speak with Ms. McFannon, but I'm wondering if there's an opportunity, maybe the parties could work out some type of agreement or something, or I don't know if the front of the court does facilitations like they do in Hillsdale and Branch County, that kind of thing, or?
We do not. We do mediation, but not through the front of the court, not facilitated.
Well,
what issues, Mr. Sanger, do you believe are in dispute at this time?
Well, I think the child lives with Mr. Henrich, so I think that Ms. McFannon, I think we could just do whatever this court normally orders for a standard timeline for mediation, that type of thing. And then I would go with Ms. McFannon and see if we can't find some common ground to get some type of order to the court.
That's fine. Ms. McFannon, what issues do you believe to be in dispute at this time?
Well, after I turned in my answer to the complaint, I got the next sheet that he gives saying like what they're doing or whatever and how and why. And a lot of them are lies and just very untrue. So
let me ask you, I don't want to get into specifics because that's not what we're here for today, but it sounds like from what you're saying that custody, parenting time, etc.
Yeah, I haven't seen my son since August. I need some parenting time.
Okay. I will put down those items are in dispute. Mr. Sanger, are you in need of discovery in this matter?
I don't, not a whole lot, I don't believe.
Okay. Well, the case is relatively new. What I do is this, I'll put a discovery cutoff date of February.
That'd be good.
Ma'am,
I'll put February 1 as the cutoff date. Miss.
Okay, so like that'll be like the end of the case then is what you're saying? That'll be like a deadline for it kind of?
No, what it is there's a discovery process whereby you get information from the other side. And you have a right to send out interrogatories, which are questions that need to be signed under oath, requests for production of documents, or depositions. You have a right to do all of that, but it has to be done by February 1, 2024, okay?
All right.
And then what happens, the court will send the matter to mediation in February if you haven't come to a resolution prior to that time. Mr. Sanger, do you have anybody you recommend as a mediator?
I like John Brundage. I think out of Marshall. He's always done a good job on family court matters.
Okay, Ms. McFannon, do you have any problem with Mr. Brundage?
No, I'm fine with this. I want this to go as quickly as possible, so I'm fine with just doing what he'd like.
Okay. Well, Mr. Brundage, I will tell you, he does about probably 80% of all the mediation in the county, so he's familiar with it and well qualified. Mr. Sanger, do you have anybody as an alternate in the event that he's not able to do it?
Boy, I don't even know. Anybody you put down would be satisfactory, Judge.
Well, I can't. The court cannot. By court rule, the court can't suggest, can't infer, or can't assign anyone other than, at least I can't. The mediation clerk can. What we'll do is leave it blank. If Mr. Brundage is not able to serve, then let us know, and then we'll have to assign someone.
Okay, thank you, Judge. We just had a lady. I think that it was in another case, but I think it was with some sort of. I can find her name, but just assign whoever, or just have I can't find the.
Well, check with Mr. Brundage and see that he's able to do it, and then if not, then we can reassign.
I had the Southeastern Dispute Resolution Services do one, and the Rebecca McCluskey was her name, and she did a good job too.
Ma'am, Miss Barron, do you have any problem with Miss McCluskey?
Totally, I'm for it. It's fine.
We'll put her down as an alternate. What was her first name again?
Judge, her name was Rebecca, Rebecca McCluskey, and she was with Southeastern Dispute Resolution Services out of Jackson, Michigan, and did a really good job.
I'll just put Ms. McCluskey down and we'll see if Mr. Brundage can do it, then we don't have to worry about that particular thing.
Yep.
Okay, court was set. I'll set March 4th as the settlement conference date. That'll give you time during February to set up the mediation. I would tell you, Mr. Sanger, to do it relatively soon because Mr. Brundage does fill up quickly.
I was going to get on his schedule very shortly.
Okay. And the parties are required to appear as we are now in Zoom on March 4th if we have not come to a resolution prior to that time.
All right.
Anything else, Mr. Sanger?
Nothing further, Your Honor. Thank you, Judge.
Ms. McFerrin, anything else by you?
I would just like to know if there's like any sort of thing that I can do. I don't care if they're like watch visits or visitation.
Yep, Ms. McFerrin.
But I have not seen them since. Sorry.
Ms. McFerrin, I'll call you later this afternoon after I wrap up my other afternoon hearing.
Okay. Ma'am, if you cannot come to an agreement with the other side, you always have a right to file a petition and come back before the court, and then the court would address your issues at that time, okay?
Okay.
So, okay, that will conclude this matter at 1:32 p.m. You're free to go. Have a good day. Ms. McFerrin, you will get a scheduling order in about no later than a week. There are various dates in that order that you have to comply with, so make sure that you read it thoroughly and completely because some of the dates, if you were to miss them, would have substantial consequences in your case, okay?
Okay.
Okay, thank you.
Thank you.
Good afternoon. Mr. Mays, in this matter, this is a scheduling conference whereby the court puts in place various dates and processes so that the case will proceed in an orderly fashion. And what I will do is I'll go to Ms. Bendelay first, and then after getting her input, I'll go to you, sir, so you will have input on everything that Ms. Bendelay does, and just doing it in order of the parties in the particular case. Ms. Bendelay, what issues do you believe to be in dispute in the case?
At this time, Your Honor, I believe it's custody support and parenting time. I'm hopeful that we will get it resolved at mediation, but I do think that's where we're headed at this point in time. I don't believe we have an agreement.
Oh, okay. Sir, anything else that you're aware of as far as in dispute in the case?
I would like to ask the court to adapt to the parenting plan that was provided.
Okay.
And
well, that means that parenting time is in dispute if basically they're not willing to do that. So I'll put it down that it's in dispute, and then we'll have to address those issues. Ms. Bendelay, are you going to need any discovery in this matter?
We would ask for 60 days for discovery, Your Honor.
Okay. Mr. Mays, discovery is the process whereby you can acquire information from the other side. You can do that through interrogatories, which are questions that need to be signed under oath, requests for production of documents, depositions, or any other means of discovery. So what I'm going to do is set February 1, 2024 as the deadline. So you have to have any discovery you'll have to have done by that date, sir, okay?
Okay.
Just so you're aware. And I will set mediation in February 2014. Ms. Bendelay, is there anyone that you would recommend as a mediator?
We would request John Brundage if the court would permit.
Okay. Mr. Mays, do you have any problem with Mr. Brundage serving as the mediator?
No.
Okay. Just so you know, Mr. Brundage does about 80% of all the mediation in the county. He's very qualified. And so it's all he does is mediation. So, Ms. Bendelay, do you have an alternate in the event that Mr. Brundage is not able to serve?
Forgive me, Your Honor. I've used another mediator with Branch County. I believe she's out of Mendon, but I don't recall her name offhand. I don't have a specific preference, so we would defer to the court.
Okay, well, the court cannot the mediation clerk can assign, the court cannot assign nor suggest or infer anybody in particular pursuant to court rules, so the court will not. What I'll do is I'll leave it up. If in fact Mr. Brundage was not able to serve or was disqualified for some reason, then I'll have you bring it back and we will get a mediator assigned at that time.
Thank you, Judge.
Court will set March 4th, 2024 at 1:30 p.m. as the settlement conference date in this matter. With that, Ms. Bendelay, is there anything else that you have before we conclude?
I would have nothing further this time.
Okay. Mr. Mays, anything else you have before we conclude?
No, I don't have anything else.
Okay. Mr. Mays, you will get this order no longer than probably a week from now. Make sure that you pay attention to the order and read it thoroughly, because there are dates that you have to comply with various things in that order. If you don't, they would have pretty substantial consequences on your case. So make sure that you comply with everything that's in the order, because oftentimes people will come into trial and they'll say they want to have witnesses testify or put in exhibits, which they haven't disclosed pursuant to the case scheduling order. They're not allowed to get those in at that time. So just make sure that you pay attention to it and get that done, okay?
Understood.
Okay. Thank you. The court will end this matter at 1:38 p.m. You're free to go. Have a good day.
Thank you, Judge.
Good afternoon to everyone.
Good afternoon.
Hello,
Ms.
Judge.
Thomas, just so you're aware, Ms. McKenzie wanted to be incognito today, so she's not appearing on screen.
Okay.
Well, I actually should be on screen, but I don't know.
You're not on our screen.
That's fine. Okay. All right. My hair's not that great today anyway, so
Okay.
go ahead.
Ms. McKenzie, we've been informed that you did have get this matter resolved at mediation. Is that correct?
We did.
Okay. Ms. Thomas, is that accurate?
It is accurate. The one part of our agreement is that because we both use different programs for front of the court, we were going to have the front of the court, for child support. We were going to have front of the court actually take numbers that we gave them and actually just run it on their system. And I prepared an order indicating that, sent it to Ms. McKenzie, and I've not gotten it back yet.
Ms. McKenzie, why has Ms. Thomas
Right.
not gotten the order back?
It is not accurate. What happened at mediation was that we agreed, because there was such a huge discrepancy. The mediator thought that there was some sort of what he called a glitch between one of the programs. So we agreed to send the child support issue to the front of the court, but we did not agree on any particular numbers. There wouldn't have been a reason for that. If we were in agreement with numbers, we wouldn't be sending it anywhere. So
Well,
yes,
not
I did
agreement
agree.
as to, maybe an agreement as to income and not the resulting numbers.
There was no agreement as to any number at all. There was an agreement to send the matter to the front of the court, and that's what is reflected. And Cindy prepared the judgment.
So you don't have any income numbers? Is that what you're saying?
Correct. But yes, that is correct. But we did agree to send it to the front of the court for child support calculation.
Okay.
Your Honor, that's from what we were told by Mr. Brundage, not an accurate reflection. The concern was because of how the programs did differ in how they reflected the incomes, and we couldn't figure out, Jen and I looked at it over and over again, and we couldn't figure out why we couldn't depict it exactly. So we did agree that to have front of the court actually run the numbers on their program, because Ms. McKenzie and I don't use the same program. But we had pay stubs at mediation. I verified after I got an email from Ms. McKenzie last week. Where did we get the numbers? I called Mr. Brundage, verified that those were from the same. I mean, he had our original numbers that I provided, but then we gotten pay stubs and whatever. And his understanding is that we were just having front of the court run the numbers as well.
Okay.
I have a call into him for that same purpose and haven't heard from him, but my notes are generally pretty good, and I have not agreed to any figures, and that's the reason that I've.
Okay. Well, what I'll do.
Not signed that order. Is that even necessary, Judge?
I think we had.
Is it even necessary?
Okay. I think maybe at a status conference, we were aware of this. I think we had, didn't we send this matter to mediation? I mean, to the front of the court? I thought we had.
There
Judge,
was, there was
we
no
had-
status conference that I'm aware of that I was part of, Judge.
No, we did not, Judge.
Oh, okay, I'm sorry. We did it on another case. I thought it was this case. And
No,
it was a different
Judge,
case.
what we did is because we contacted front of the court after mediation, and front of the court said absolutely not. They would not run any numbers without an order from you. So we contacted Christy, spoke with her, and she indicated that if it was an order signed by both of us with the numbers that they needed to use and whatever, that you would sign it. And so that's where we're at. And I didn't get that order back, that proposed order back from Ms. McKenzie.
Okay.
I've never heard anything about a conversation with your staff, Your Honor. And I don't have, but it's still, the fact is that I don't have any figure in my notes, which would be unusual, you know, to try to be putting everybody in this spot. If there wasn't.
Well, why can't we agree to send the matter to the front of the court? And then the two of you can submit the income information. If it turns out there's a dispute on that, then we'll have to address that. But if there's no dispute on what their income is, then the front of the court can do it. We can get that done.
That's fine. And I've been waiting for Cindy to send me her client's new employment information. Haven't gotten that yet, but it's possible that she hasn't gotten it from her client yet either.
Okay.
So yeah, that would work. And that would also be, Judge, that would also enable you to sign the judgment, I think, today, because the judgment has a general statement of we're sending this to the front of the court without any numbers. So I think, and we did approve the JOD on the date of mediation.
Well, Ms. McKenzie, why don't you sign the order, get it back to Ms. Thomas, you can get it to me. We can get the front of the court going on doing the calculation.
I have actually already approved the judgment of divorce, which does say that we're sending it to the front of the court for calculations.
Okay.
I have not approved a separate order, which I don't think was necessary, but I understand Cindy was following front of the court's marching orders. I don't think a separate order is entered is necessary. Do you, Judge?
Yes, sign the order because we'll get that order to the front of the court before we get the judgment to them.
Judge, she's not going to sign that order because that order has numbers in it, because that's what Mr. Brundage indicated that was his understanding and my understanding we agreed to. So if Ms. McKenzie as the plaintiff wants to just prepare a quick order or if you want to do a jiffy order, just sending it to front of the court, that's fine with me as well.
Okay. Well, why don't we do this? We'll send it to the front of the court just to do a support calculation. So we'll do that. So that way we don't have to wait on either of you to get orders, and it doesn't sound like the two of you are going to agree to much. So we'll get that taken care of.
Judge, I do have a general question. Do you use the Michigan Child Support Public Calculator yourself? I
don't use anything. I don't do support calculations. That's why we send them to the front of the court.
In the meantime, I am fine, and I don't want either Mr. Smith or Ms. Tapley Smith to have to come back to court again unless there's something major with those calculations. I'm fine with proofs being preserved today because we do have a signed judgment of divorce, and the only thing that's hanging is justice front of the court, and we have already agreed that it's going to go to that front of the court's going to run the calculations. So I think we're fine to go ahead and at least preserve proofs. And then obviously it can't be signed until front of the court approval and all those things. But that way they don't have to come back to court and take time off from work or whatever.
Okay.
That's
okay.
If we can.
Ms. McKenzie, would you be willing to do that today?
That's fine. Yeah.
Okay.
Sure. And were you married to Tabitha Nicole Tapley, Tapley Smith, on August 14th of 2016?
Yes.
And did you and Mrs. Smith have one daughter turned 8 yesterday?
Yes.
And has there been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is it true that the communication between yourself and your wife broke down and it just can't be repaired, and that was the cause of the breakdown of the marital relationship, or one of the causes? Is that accurate? Okay.
Yes.
Are you asking the judge to sign the judgment of divorce which you approved on November 7th, 2023?
I am.
May it please the court.
Okay. Mr. Smith, prior to filing your complaint, had you resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing of the complaint?
Yes.
Do you know, is your wife currently pregnant?
No.
Thank you. Court will find that the testimony does establish the statutory basis there has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment in this matter, as well as UCSO, when we're able to get that completed. And we will send out that order, by tomorrow at the latest, and hopefully get the front of the court to do a calculation.
Thank you, Your Honor.
Okay, thank you. That will conclude today's hearing. We'll end this hearing at 1:56 p.m. You're free to go. Have a good
Being
day.
filed, were all the statements in the complaint truthful?
Yes.
And are they still truthful today?
Yes.
You would indicate in your complaint for divorce that you had resided in Calhoun County for at least 10 days and in the state of Michigan for at least 6 months. Is that correct?
Yes.
And to the best of your knowledge, is your wife pregnant?
No.
And you also indicated in your complaint that there were issues between you and your wife that you had a child. Is that correct?
Correct.
Okay. And you have in fact participated in mediation in this matter?
Yes.
And were things resolved at mediation?
Yes.
And you in fact we did not.
Oh, you're right. We did. We did everything before.
I'm
Sorry.
sorry. We did.
No, we skipped that because we agreed.
We did.
Yes.
We reached the settlement
Sorry.
before mediation. I'm sorry. That was my bad. And I didn't mean to lead you with the bad question.
You're good.
Sorry. So we made a settlement offer prior to mediation. Is that
Yes.
correct?
Yes.
And that was accepted.
Yes.
And you have in fact reviewed a judgment of divorce.
Yes.
And you signed the same.
Yes.
And you believe that adequately and accurately reflects the settlement in this matter.
Absolutely.
And is in your child's best interest.
Yes.
And you also believe it's an equitable settlement between you and your wife.
Yes.
And then you also did you not review the documents that show both Attorney McNiff and your wife's signature? Is that correct?
Yes.
And you recognize that as your wife's signature?
I do.
And you're asking then that the court go ahead and enter the judgment of divorce as well as the uniform child support order?
Yes, I am.
May it please the court.
I might have missed, Ms. Thomas, you established the breakdown.
I did not, I'm sorry. Is there, you had indicated in your complaint for divorce that there had been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Is that true?
That is true.
Can you please briefly describe to the court what caused the breakdown?
Me and my wife have different agreements and perspectives on what a relationship entails. She wishes to be polyamorous with multiple partners, and I wish to be monogamous with one single partner. We don't see eye to eye, so we would like to part ways.
And is there any possibility that you could reconcile your differences and live together as husband and wife?
No, absolutely not.
May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship, and the court will preserve the proofs in this matter pending receipt of the approved documents. Sir, you're not divorced until I actually sign those papers, so it may still take a bit of time to get those concluded, but we will, as soon as we get those in, we will get them entered, and then you would be divorced at that time, sir. So good luck to you. I hope everything works for you.
Thank you.
Court will end this matter at 2:01 p.m. You're free to go. Have a good day.
Thank you so much.